Another hot button issue under consideration at the court this term, gender transitions for minors. As dozens of states move to either ban or protect gender reassignment treatments called gender affirming care by advocates, some groups are asking the Supreme Court to intervene. 3 cases have been submitted to the Supreme Court over bans on gender transitions for minors. 2 cases ask the High Court to reverse bans in Kentucky and Tennessee. A third asks the justices to allow Idaho's ban on gender transitions to take effect after a lower court judge blocked it earlier this year. Another case on the court's desk, MC and JC versus Indiana, brings up the issue of parental rights. Parents Mary and Jeremy Cox's teenage son began to identify as a girl, but because of their Catholic faith, they did not use his preferred pronouns. Indiana Child Services stepped in and removed their son from their home, even though it found no evidence of abuse or neglect and never returned him to his family. The parents hope a ruling from the U.S. Supreme Court could affirm their rights as parents to teach their children their deeply held Catholic beliefs on gender and sexuality, and to protect others from losing custody of their children over their religious beliefs in the future. 2 legal experts join us now to discuss these cases. Lori Windham is Vice President and Senior Counsel at the Becket Fund for Religious Liberty. She's the attorney for the Cox family as they bring their case to the Supreme Court. And Josh Payne is a partner at a law firm that helps detransitioners sue their doctors for pushing gender transition surgeries. The law firm is Campbell Miller Payne. Thank you so much for joining us for this conversation. Lori, let's start with you. What happened to the Cox family? How does the right of a child to change their gender supersede parental rights?
That's exactly what we're asking here, Montse. Mary and Jeremy Cox are living every parent's nightmare because they would not change those pronouns and go along with a attempted gender transition for their son. He was removed from their care by state officials, even after they investigated for months and found out that these were fit parents. They had not abused or neglected him in any way. They still used the disagreement over gender as a reason to keep him out of their home until he turned 18. What's shocking is the Indiana courts upheld this, and now the Supreme Court is their last stop and their last hope to make sure this doesn't happen again to others.
So then what is that hope? What could the Supreme Court do? Could they force Indiana to return him to his family? What comes next?
What the Supreme Court could do is overturn the decision below, wipe this stain off of Mary and Jeremy's record. They have other young children at home. They don't want something like this to happen again. And send a clear signal to lower courts and to states that you cannot interfere with parental rights. You cannot interfere with religious liberty by removing kids from the home of loving parents just because they disagree over gender.
Josh, let's talk about these transition bans. You recently filed an amicus brief on behalf of detransitioners in Idaho's case to the Supreme Court. And in that brief, you shared the stories of numerous detransitioners, people who are trying to come back to their original gender, who believe that gender-affirming care would resolve their gender dysphoria and allow them to live healthy lives. But as you say in the brief, they learned through these experiences that such interventions did not resolve their mental health issues or gender dysphoria, but only caused physical harm and increased their distress as they realized their bodies had been irreversibly altered based on a false promise. How do you hope the stories of these detransitioners will help Idaho's case with the Supreme Court?
We do hope that their stories are heard and listened to, and we know that they're effective and that they help cut through the noise and really put a face to why these regulations are so necessary and so important. In the lower courts, in the Kentucky and Tennessee case that you mentioned, that the government and the private plaintiff challengers are trying to get the Supreme Court to hear, we also filed an amicus brief in support of the Kentucky and Tennessee laws. And in its ruling, upholding those laws and protecting minors from these dangerous procedures, the United States Court of Appeals for the Sixth Circuit cited our amicus brief on behalf of detransitioners and said what this brief shows and what the detransitioners show through their testimony is that the category of transgender such as it is, as the private plaintiffs are claiming, it is a protected category, is not an immutable characteristic, because people can change and detransition, as our clients have, after they realize, in their words, that they were misled into these physical changes to their bodies that did not help their mental health, gender dysphoria problems, but instead simply left them with mental anguish, and in many cases without their natural healthy bodies and without their body parts.
Absolutely. Well, Josh, are there any common themes then in the stories of these detransitioners? Your law firm is one of very few that is helping them with their plight, which has been much silenced in the mainstream media.
That's right. At Campbell Miller Payne, our firm, we were established almost 1 year ago to represent detransitioners and help them seek justice from the medical providers, the clinics that put them through these treatments. As I said, our clients feel that they have been misled into these procedures. They are seeking justice for themselves and their families, and they are hoping that by bringing a case, they not only stand up for themselves in seeking that justice, but that they also serve as a cautionary tale in hopefully preventing this tragedy from happening to others.
Now, Lori, these detransitioner clients and stories are the worst case scenario for your clients right now. Are there any other states where children are being taken from their parents in this way?
Yes, Montse. California and Washington have both passed laws that authorize state officials to take custody or to refuse to tell a parent where a child is if that child, for the purpose of allowing that child to access what they deem gender-affirming care. Other states like Maine are considering similar bills. What we've said all along about the Cox's case is that if this can happen in Indiana, this can happen in
Now, Lori, it seems that a place like California, we would expect to have that kind of a reaction, pushing gender ideology, violating religious freedom and parental rights. But Indiana, that's quite surprising. Why is it happening there?
Well, I think it really does send a frightening message that state officials in any state, if they have these views about gender transitions, can remove a child from a parent's home. And it can take months, if not longer, for parents to be able to clear their names and get their child back.
That's true. Well, now, Josh, it's not just government regulators and bureaucrats that are at fault for some of this. Sometimes it's medical associations, but this time a medical association has actually done something positive. The American College of Pediatricians has concluded that social transition, puberty blockers, and cross-sex hormones have no demonstrable long-term benefit on psychosocial well-being of adolescents with gender dysphoria. Do you think this finding could impact the High Court's decisions when it comes to gender-affirming care or so-called gender-affirming care?
I think it's very important that all courts, and of course the Supreme Court especially, have available to them the best science possible, and that the experts are really able to explain what the science is telling us, what it is not telling us, and what it can't tell us. And where it is and isn't being deployed appropriately. In our medical malpractice cases, of course, we have experts giving opinions about the standards of care and how that was carried out in specific cases. Something like the American College of Pediatricians is very important because it shows industry-wide, if you will, the expectations that are there for how children should be protected and how they should be cared for and what is and is not appropriate. Going back to the Tennessee and Kentucky cases, which are pending, the government, the federal government, and the private plaintiff challengers asking the Supreme Court to take those cases and reverse the Sixth Circuit, which upheld the laws to protect the minors. There is a very good friend of the court amicus brief there filed on behalf of the state of Alabama that lays out the lack of scientific evidence underpinning the so-called standards put forward by WPATH, the World Professional Association for Transgender Healthcare. And that is a document I commend to everyone to read because it really shows that the so-called science that's being used to push these procedures is very much lacking and not what people have been led to believe.
Well, there's certainly concerns for religious freedom, parental rights, and of course, actual science that the courts will be watching this very carefully. Thank you both.
Thank you.
Thank you.